to the overcoming overcriminalization panel on how you can combat the criminalization of capitalism, brought to you by the Texas Public Policy Foundation and Right on Crime. I am the moderator, Eric Erickson, editor of redstate.com. We're going to begin with a couple brief statements from our panelists, and then we're going to allow you questions at the end. I want to introduce the panelists first. We'll start on the end and work our way back, and then we'll, with opening statements, work our way from this way back down. So on the far end is Paul Larkin. He directs the Heritage Foundation's Project to Counter Abuse of the Criminal Laws and Senior Legal Research Fellow of the organization's Center for Legal and Judicial Studies. Before he was at Heritage, Paul served as an assistant to the Solicitor General at the Department of Justice and an attorney of the Criminal Division section on organized crime and racketeering. He argued 27 cases before the U.S. Supreme Court, worked for Senator Orrin Hatch in the Senate Judiciary Committee, and received the Secretary of Defense's Medal for Meritorious Civilian Service representing the military before the Supreme Court. Isaac Gordetsky is the project manager of the Center for Legal Policy at the Manhattan Institute. Prior to joining the Manhattan Institute, he was the president of the Federalist Society at New York Law School. Mark Levin is the director of the Center for Effective Justice at the Texas Public Policy Foundation. Prior to the foundation, Mark served as a law clerk to Justice Will Garwood on the Fifth Circuit Court of Appeals and staff attorney at the Texas Supreme Court. Mark is an accomplished author on legal and public policy issues and was heavily involved in the corrections reforms that took place in Texas. Now let me explain the issues for you. Overcriminalization, there's a great report out today. Anyone have any idea what the fine is in Chicago for parking in front of a fire hydrant? $100. $100 fine, park in front of a fire hydrant. Any idea what the penalty is if you park a food truck within 200 feet of any establishment that sells any food product, including a gas station? $500 in potential jail time. The restaurateurs in Chicago have managed to criminalize food trucks, park anywhere near them, giving them competition. We live in a day and age where it becomes a lot easier for General Motors to hire a lobbyist to go to Washington and carve out loopholes in the tax code that put them in a competitive advantage against competitors than it does to actually innovate. We live in a world where big businesses can criminalize acts that make it difficult for small businesses. We live in a world where there's such a growth of the federal criminal law that you have district attorneys and local governments who, well, it becomes harder for them to operate. I am interested in this topic and was glad to serve as a panelist. Because I was a lawyer for 6 years. I mostly did election law and corporate transactions, but I was a volunteer in criminal defense attorney for 6 years in Middle Georgia. The amount of time I spent on frivolous issues that shouldn't even be crimes, and it's gone on and on. Thousands of frivolous activities are now classified as crimes in the United States. There are over 4,000 existing federal criminal laws. In addition to the federal statutory crimes, there are state crimes. Texas has 1,700 crimes. Texas, people, Texas. Federal regulatory offenses number more than 300,000. It has an impact on small businesses. It has an impact on individuals. These are the crimes that come after the little guy, and they clog the system where we should be going after the big fish. Now, we have three distinguished panelists, as I've introduced them: Paul Larkin, Isaac Gordetsky, and Mark Levin. I'm going to let Mark start, and we'll move our way down the table for opening up questions.
Well, thanks so much for having me. Actually, as I was looking at the paper here just a few days ago in Florida, someone was arrested for charging their cell phone in a park for theft of power. Anyway, it's quite interesting. I suppose perhaps it's all the green energy mandates that are driving people to crime, just like increased cost of power. But what I wanted to do today is focus on a couple of documents which you have, which is our checklist, Analyze Before You Criminalize, as well as more recently our 12 steps for overcoming overcriminalization. And I've written way too many lengthy papers, so these are a bit more digestible and really go to the heart of this. And I think y'all wouldn't be in this room if you didn't realize we had a bit of a problem with overcriminalization. So what really I'd like to focus the most on is how do we address it. So I guess the most basic question is, should something be against the law? And the fundamental question is, do we need the government to step in, or can the market handle the issue? And we also need to most certainly ask, is there a victim? Is there harm to an actual person that causes us to want to criminalize something? And so things are generally, the idea, the original definition of a crime is a guilty mind plus a bad act. And the other problem we're seeing is the erosion of mens rea, where many things are strict criminal liability crimes now, meaning you can be convicted even if you have no level of intent. So one of the other things that we've got to do is start looking at what are the costs of creating all these crimes in terms of enforcement and so forth. And in your particular state, I would encourage you to look at the fiscal notes, whether you have a good fiscal note process that covers what is the cost in terms of not only incarceration, but local governments in terms of courts, jails, prosecutors, their time that's being devoted to this. You know, there's, I think, a false assumption that prosecutors necessarily support overcriminalization, but most of these crimes, as we look at in different states, particularly related to ordinary business activities, have come from one business lobbying to put another out of business. They come from occupational licensing, which is a lot of what I just said, people trying to put others out of business. And the prosecutors, many of them have actually said, look, you're making us be a free lawyer. Because once you establish something as a criminal penalty, if someone files a complaint against someone else or one business against another, the prosecutor has to look into it on government time. And there's a lot of boutique crimes where we criminalize something 50 or 100 different ways. Like stealing copper, for example, we see a lot of use. That is something that should obviously be a crime, but that was already a crime, but now we create these boutique ones, which many prosecutors say clutters up the penal code, makes it more difficult for them to do their job. So those are a number of the issues that we see. Another one is the delegation to agencies, both at the federal and state level. So for example, in Texas, we have laws that say any violation of an agency's rules is a Class A misdemeanor punishable by 180 days in jail. And so therefore, the average citizen, whether it's EPA or some state agency, every week that they have a meeting and create new rules, they're able to effectively create new crimes without approval by a democratically elected body. So we need to rein that in. So here, I'd like to point to our 12 steps for overcoming overcriminalization. And the first one deals with the issue of mens rea. And there's a draft model legislation that we've gotten unanimously passed through ALEC, American Legislative Exchange Council, which provides a default mens rea provision. That is, if a statute, an offense is silent on whether there's any level of intent required for conviction, this default provision kicks in. And, you know, this comes up in a lot of circumstances. You know, business, certainly, you had a guy at a nursing home several years ago in the Washington, D.C. area, a janitor who didn't know the waste was being discharged the wrong way. And so he was convicted because, again, the law didn't require any level of intent. Then you see it at the zero tolerance in the school, where a student brings an asthma inhaler to school but doesn't register with the nurse. Again, it didn't matter that they didn't know they should have done that. Of course, you've also seen in Houston, there was a kid with a pocket knife in his jacket. He was hunting with his dad on Sunday, had no intent to use it, but of course he ended up expelled and convicted. So providing this fundamental protection is critical, that there be this default culpable mental state when the statute is silent. So we'd love to work with many of you to try to move that forward in your state. There are about 20 states that have a default mens rea provision, but the rest of the states do not. The other one is the rule of lenity. Now this sounds kind of arcane, but it's kind of like a tie goes to the runner in baseball. And that is, the rule of lenity says if the statute is not clear that something is prohibited, then the court should err on the side that it's not prohibited. And again, we have model legislation enacted by ALEC that would create the rule of lenity, which only a few states currently have. Of course, we want to not criminalize offenses based on voluntary economic transactions. And of course, that does mean we say fraud is something that is appropriately criminalized. But when you don't have the element of fraud, really you don't see a need for a lot of criminal penalties as it relates to business activities. And among the others that we talk about here are when we talk about requiring that there actually be harm to the victim or in the context of the environment, certainly then there should be a requirement that, some animals be harmed by whatever the person did. But look at it, like in Texas, we have laws that say it's a crime to mislabel fruit. It doesn't matter that no one got hurt or even could have gotten hurt. The fruit was perfectly good, but just the fact alone that it's mislabeled is a crime. So that's something. And then also we have crimes for applying pesticides and things. But again, there's no element in it that says there has to be an injury to human health or even an injury to the environment. Again, we also need to look at consolidating duplicative laws. We also need to look at reclassifying. one of the interesting things that many people don't realize is as soon as you have the possibility of jail time on an offense, that means someone's entitled to a lawyer paid for by taxpayers. Usually it's at the county level in terms of indigent defense. So if you actually take jail time out of some of these things and say it's a fine-only offense, or even better, make it a civil violation, only pay administrative fine or lose a license or permit, then you no longer have to provide free lawyers. So you're talking about saving the taxpayers a lot of money, and also not giving people a criminal record for something that really doesn't warrant that. And the same goes for distinguishing between misdemeanors and felonies. I think we really need to have clear criteria. There's 3 of them that are set forward in this document. The other thing that I think some states have done, and somewhat promising, and by the way, other countries, is creating some type of commission. Now, I know this always sounds, especially in the days of super committee, like we're just punting something. But there truly is, when, as Eric said, in Texas, when you see 1,700 criminal laws, it is very difficult to repeal them one by one. And many of them are just dead wood. You have a whole statute criminalizing something related to industrial homework, which no one knows what it is anymore. But there's not much to be gained by a legislator filing a bill to repeal things. I mean, some people have suggested, I think John Stossel said, for every bill creating something, there should be a bill repealing something. But that would probably be in our ideal world. So what you do is you create a commission with prosecutors, judges, voluntary thing, to look at the whole criminal code and make recommendations to the legislature. And they did do this in Illinois and Kentucky with some success. It was actually done with more success in Ireland and some other countries. There's a professor at the University of Pennsylvania Law School named Paul Robinson who came in and helped several folks to do this. And what you find is actually a lot of consensus on things that are redundant or unnecessary among prosecutors, judges, criminal defense lawyers, everyone that's involved in the effort. Now, I know we're focused here mainly on our states, but I wanted to also just point out the 10th Amendment, because at the federal level, this is really part and parcel of the problem. We are seeing now with over 4,500 federal statutory crimes, then the hundreds of thousands of federal regulatory crimes. Many of these, of course, far exceed what the federal government's constitutional power is. I think there's no issue that's more fundamentally a state or local issue than criminal justice. And so I think on the right side of the spectrum, there's been a bit of hesitation perhaps to apply 10th Amendment principles to criminal justice because, of course, you see things like, for example, the Adam Walsh Act, which deals with sex offender registration. You see things like animal identification. The federal government must require every farmer or rancher to register all the animals with the government. But we've got to say, look, whether we think these things are really bad or not, they're not federal issues. And so we need to really look at peeling back the federal role in criminal justice. And I think letting the states and local governments do what has traditionally been a state and local function. So I did want to just wrap up by saying, as you work with us on this, I think our president was just in the room a little earlier, Brooke Rollins. We also have Jeanette Moll, who's right there, back there, who works with me on criminal justice. It's a great resource. And Jordan Brown with here is helping us with the multimedia. So we really want to work with you in your state on this issue. We have an opportunity next year to go into a number of states. We work in Rhode Island and also Ohio. We have a bill on the default mens rea that we believe a state senator in Ohio is going to be filing. So we'd like to get some legislation moving that takes some of these steps to rein it over criminalization in your state. So please let me know. Come see me afterwards. Contact me if you'd like to work with us in your state. I think it's a great issue that can unite people across the spectrum and really make a difference in favor of liberty in your state.
Next up, Isaac Gordetsky, the project manager of the Center for Legal Policy at the Manhattan Institute.
Thank you. I'm very excited to be speaking to you guys today on the topic of overcriminalization. I'm bringing to this issue relative to my co-panelists here who are real leaders and gurus. They can tell you everything you need to know about overcriminalization, which I guess it makes you wonder why I'm here. But I think the answer to that is this topic is so broad, it's such a broad umbrella that there are different ways to approach the issue. And that's the first thing I noticed when I started working on this issue, is the coalition of groups working on it is so diverse, from Heritage to Cato Institute to the ACLU to Families Against Mandatory Minimums. I think it's really telling that groups that probably disagree about 99% of all major issues will come together to agree that overcriminalization is a problem and that it's something that needs to be addressed. So what I want to talk to you about today is what Manhattan Institute has done to help lead this effort and what we've learned along the way. So what we wanted to do is focus on this issue on a state level. Before we came up with a strategy, we started with New York, because it's our backyard, and we wanted to see what kind of issues would pop up. And so we figured out that that New York was no different. It followed the national trend of overextending the reach of criminal law, and the legislature added many new laws and sanctions to the books that didn't comport with traditional common law principles. And perhaps the most alarming thing that we found was the criminal law spilled over to the regulatory rulemaking process, which is outside of the legislative process. So basically, the general trend has been to criminalize more and more conduct. Both within and outside the New York Penal Code, the number of crimes multiplied. There wasn't just the number that we were concerned about. It was the type of crimes. So the New York Code makes provisions for, as Mark was talking about, strict liability crimes. With no mens rea, no intent to commit the crime was needed for it to be a criminal offense, and also provided for omissions, where there was no actus rea needed. It would just be an omission rather than a commission of a crime. And unfortunately, while the code does have a default provision against strict liability, expressly called by for a statute, strict liability crimes specifically have proliferated through the code in New York. So there are criminal offenses in 65 areas of New York's consolidated laws and in 8 areas of the unconsolidated laws. To give you an idea, that means there are criminal offenses in areas like agriculture and markets, arts and cultural affairs, education, energy, environmental conservation, lost and strayed animals, parks, recreation, and historic preservation, all with criminal offenses. And then some of these laws contain these catch-all provisions that Mark also mentioned, which made any breach of these voluminous regulations a criminal offense. So, for example, I have here in front of me the provision from the Environmental Conservation Law. It says any person who violates any provision of the Environmental Conservation Law or any rule or regulation shall be guilty of a violation punishable by 15 days in prison for each day the violation occurred. Which means that if you violated a regulation for every day for a year, you face up to 15 years in prison, no matter what that regulation is. So if I'm starting to sound a little bit overwhelming here, I apologize, but that's not the end of it. It's only the beginning. So New York also empowers municipalities and regulatory agencies with criminal rulemaking authority, which makes it essentially impossible to know all of the crime and be unnoticed. And basically everyone, probably including the people in this room, if you were in New York, would be guilty of criminal infractions on a regular basis. And again, it isn't just about the number, it's about the quality of these criminal statutes, many of which are vague and ambiguous, make it impossible to know, even beforehand, whether or not you're committing a crime. Even if you know the statute exists, even if you know the statute's provisions, it's still hard to know whether or not you're going to commit a crime. Then there's the issue of empowerment of prosecutors through overlapping criminal statutes. For example, New York has enterprise corruption portion in the penal law and money laundering provisions. And these were kind of like the New York versions of the federal RICO statutes. They were created to target organized crime syndicates, so the mob. Now they're being used to go after ordinary business activities deemed to be fraudulent. So the same things that we used to go after the mob for, we're going after stock brokerages and executives. And though you may have the argument that they are the same thing, the mob and executives, the reason they do that is because prosecutors have a great deal more leverage when using these particular offenses than if they were limited to the underlying predicate offenses. Obviously, these crime offenses have much greater penalties associated with it. The New York legislature continues to pass laws annually which expand the penal code. Some of these are valid. They target real offenses like fraud, assaults, and sex crimes. And some of them are more questionable, constitutionally especially. So there's a criminal offense of aggravated harassment, which subjects someone to potential imprisonment if he, quote, communicates with a person anonymously or otherwise in a manner likely to cause annoyance or alarm. So looking beyond the fact that annoying speech is protected by the First Amendment, the bill's sponsors still went on and said, causing fear and annoyance to anyone should be illegal. which is not much guidance, I think. But that's not the only way that you can go after, kind of getting authority to exercise greater criminal enforcement, which leads me to my favorite overcriminalization issue in New York, which is the Martin Act. I don't know if any of you have heard of it, but it was passed in 1921 in New York when there was no real federal securities fraud law in the books, and it was one of the blue sky laws. It was confined mostly to improper securities offerings, to boiler room fraud, and small-time fraud. And now it allows the AG to go after financial fraud, right? But we all know there's core elements to fraud. Here's what the Martin Act kind of looks like now. It's a bill that has no requirement to prove the intent to defraud. It has no requirement that anyone relied on the alleged fraud, no requirement that anybody was injured by the fraud, and no requirement that any security transaction took place. So when you have a state AG that's allowed to investigate and punish financial fraud with free rein, I think that broad authority can be just extremely dangerous. And though this act was so powerful, it wasn't until Eliot Spitzer came into office that this started really being an issue. And he went right after New York investment banks first. He had the theory of conflict of interest, that there was misleading investors, and he took down a $1.4 billion settlement from 10 of New York's biggest investment firms. And then the key that what he did was through the AG's offices, he changed business practices and industry standards, which is basically a regulatory rulemaking function from the Attorney General's office. Then he went on in 2003, went after mutual funds, extracting about $1 billion from that industry. Again, new industry standards, new business practices. 2004, went after Marsh & McLennan, a risk and insurance brokerage firm, and AIG. Marsh's stock dropped 24% after that. AIG's stock dropped 10%. In March 25, by that point, Spitzer already had $850 million extracted from Marsh and McLennan. That was more than twice the company's net income. And the ironic element of Spitzer's assault on the financial industry and the Wall Street companies that he targeted is here in New York is Wall Street's the lifeblood of the New York economy. And it's uncertain how he really helped his constituents in these efforts. Even in cases where Spitzer identified actual criminal misconduct, there's little reason to be confident that the changes which he coercively imposed, adjusting to actual business practices, firing CEOs, did not, at least in some cases, severely compromise the economic model of some of these businesses and industries that he targeted, and negatively impacted the customers which he was trying to help in the first place. I want to read a quote from Professor Henry Mann that appeared in the Wall Street Journal, which is really a great description of what Spitzer did. Mr. Spitzer introduced the world to yet a new form of regulation, the use of the criminal laws as an interim weapon to force acceptance of industry-wide regulations. Those rules are not vetted through normal authoritative channels, are not reviewable by any administrative process, and are not subject to even the minimal due process requirements our courts require for normal administrative rulemaking. The whole process bears no resemblance to a rule of law. It is a rule of force. So unfortunately, the trend didn't stop with Spitzer. We have an Attorney General right now, Eric Schneiderman, who's going after the natural gas drilling companies. And everyone kind of knows he's a known opponent of hydrofracking. So, it's questionable, at least implying that the criminal law is being used to pursue policy goals. And that's exacerbated when companies are threatened with criminal action without formal charges filed or evidence presented. So we looked at all of this, and it's important to also understand while we were doing this that New York had another really amazing trend, and this is a trend for the good, that violent crimes, property crimes, since the mid-90s were dropping in New York very severely. And so we didn't want to start calling for paring back criminal laws and regulations while things were going well. So we didn't want to turn back the scale of all the progress that was being made. So we had to reject the hypothesis that the statutory expansion, the rulemaking expansion, was somehow linked to New York's amazing crime turnaround. And we did that by kind of analyzing and saying, well, if there was a statewide increase in these statutes and regulatory rulemaking, why wasn't the decrease in crime felt across the state? Why was it only New York where we saw these drops? And the reason is because in New York, it was the policing that was causing these drops in crime. And so the policing, just to quickly go through, is twofold. One is the broken windows theory, And it may seem strange for somebody who's a critic of overcriminalization to, advocate for enforcing petty crimes like vandalism and public urination and jumping subways, but enforcing quality of life criminal offenses is not the same thing as regulatory offenses. So it's not the same thing as harassing pursuit of corporate enterprise or throwing heavy sentences at nonviolent offenses. Breaking someone's window, skipping a subway fare, they're universally understood to be criminal acts. Even though they're petty, they're still universally understood to be criminal acts. And while virtually everyone is guilty of some sort of regulatory infraction on the state or federal level, not everyone breaks windows. So it turned out also that curbing these petty crimes allowed the police to apprehend suspects for more serious offenses. So the second factor is CompStat, which is a data-driven crime-fighting system which analyzes statistics and data to understand how to best allocate resources and measure results. So basically, the whole point is there's a real case for saying that the solution to stopping crime is widespread implementation and application of successful policing tactics, not the explosion of the crimes statutorily or through regulations. And some of the solutions that we've proposed, and a lot of them kind of dovetail with what Mark was saying, is to consolidate the many duplicative, overlapping, invasive, logical crimes scattered within the code, to eliminate the default rules which automatically convert any regulatory offense into a crime, to subject all crimes to rigorous vagueness and constitutional review, to amend the Martin Act, and to restrain some of these AGs and prosecutors, to force them to kind of build their case before going public and using their leverage, and to limit these enterprise corruption laws and other laws to their original focus. So that's our initial take on New York's overcriminalization issues, and now we'd like to expand our focus on other states. Many of you may kind of, in my kind of talk, heard things that may apply to your states as well, and we want to identify that. We're especially looking to states like Illinois, Massachusetts, Ohio, Minnesota, states with vibrant financial markets, to see where this is a real problem for economic liberty. So if any of you are interested in collaborating on this, we'd love to work together, and we think this is an issue we can make a lot of progress if we just work together and combine resources. So thank you.
Thanks, Isaac. Our last speaker is Paul Larkin, who directs the Heritage Foundation's Project to Counter Abuse of the Criminal Law, and Senior Legal Research Fellow in its Center for Legal and Judicial Studies.
Thank you, Eric. It's a pleasure to be here today. I thank you for the opportunity that you've given me to educate you and try to persuade you to be concerned about this problem. I appreciate the time that you're spending here, and I also appreciate the opportunity to be on a very distinguished panel with Mark and Isaac. I'm going to talk about two things. A little bit about the problem, because you've heard a lot of the problem already, and then more about a proposed solution that I think might be helpful that I would encourage you to consider in your own states. Every child early in his or her life recognizes the unfairness of being punished for something that he or she didn't know was out of bounds. It is a common and classic human problem. Punishing somebody for something that he or she did, where that person knew it was impermissible, knew it was wrongful, knew it was dangerous or harmful, is not what we're talking about today. What we're talking about is punishing somebody for something that he or she would not reasonably have known was illegal, immoral, dangerous, or otherwise sufficiently questionable that someone should hesitate, perhaps even refrain from engaging in the conduct altogether. What we have here is a situation that has developed principally in the last 100 years. For most of our legal history, the criminal code and the moral code were congruent. If you committed a crime against God, you committed a crime against a king. And so being charged with one of the very few crimes that existed in common law, murder, rape, robbery, burglary, larceny in one form or another, could not have come as a surprise to anyone. You knew what was yours and what wasn't, even if you had very little, and you didn't go around taking things from others, whether it was property, their liberty, or their life. That made it relatively difficult for someone to claim surprise when he or she was charged. I think the Gibson Guitar Company had a very different reaction. As you may remember from reading about it in the newspaper, the Gibson Guitar Company is a famous company in America. They have made guitars for people such as Eric Clapton, a personal favorite one, Jimmy Page, and a lot of other well-known guitarists. Gibson was importing wood for guitar frets. Keep that in mind. We're talking about wood for guitar frets. We're not talking about heroin. We're not talking about C4. We're not talking about Stinger missiles. We're not talking about replacement parts for automatic weapons. We're talking about wood for guitar frets from Madagascar and India. It turns out that at least there was some question as to whether the law of Madagascar and India was violated in the importation process. Keep in mind, if it was, and there's no certainty that it was, there's also no reason automatically to believe Gibson was involved. After all, in importing this wood, Gibson used an intermediary from Germany to do the importation and reasonably relied on the representations of that German company that it didn't go out and just steal something from somebody's backyard. Be that as it may, the federal government, acting on a complaint, most likely from an environmental group that ironically had encouraged Gibson to travel with it to Mozambique and India, conducted a criminal investigation of Gibson for unlawfully importing wood in violation of a federal law known as the Lacey Act. The Lacey Act was originally passed in 1900 to prevent interstate poaching. It was designed to prevent somebody from going from Pennsylvania to New Jersey, violating New Jersey's hunting laws, and going back to Pennsylvania at a time when there weren't the interstate transportation facilities we now have, there weren't the interstate communications facilities we now have, and so the federal government got involved simply because it was necessary in order to protect one state's flora and fauna, or actually just at that point, just the livestock and the wild game, from being pillaged by people from another state. Now, however, it prohibits the importation of any flora or fauna from any country on the planet in violation of any law of one of those countries. It doesn't have to be a criminal law. It doesn't have to be an environmental law. It can be a labor law. In fact, in the case of India, the alleged violation was that there was an insufficient amount of labor put into the product before it left India as a requirement of their own labor laws to make sure that people who in India got a chance to work and earn a paycheck based on this. And also, by the way, it doesn't even have to be a law that's written in English, because the law in Madagascar wasn't. So you can imagine what it was like for a company in the position of Gibson Guitar to all of a sudden be beset with a lot of federal agents coming in. And one of the things Eric did mention to you is that I used to be a federal agent, so I know what it's like to be conducting a search of business premises. And if you're on the receiving end, it ain't a lot of fun, trust me. There are times it's necessary, but not always. And in any event, it is always nerve-wracking. Now, keep in mind also, we're talking about Gibson Guitar. We're not talking about DuPont. We're not talking about Dow Chemical. We're not talking about a major Fortune 100 or 500 company. Those are not the companies, those are not the people who are at risk from this sort of conduct. If you're the president of a Fortune 100 company, you have a legion of lawyers in your own legal counsel's office. You have a flotilla of law firms waiting for you to call them to ask them for advice on these things. CEOs of major companies are not at risk. Plus, CEOs of major companies have scads of people below them who won't even tell the boss about problems because they're afraid of being punished for something going wrong on their watch. I mean, that's just a general corporate governance problem, but it also is in fact true. The problem arises for small and medium businesses and white and blue collar workers. They don't have white shoe law firms on speed dial, and yet they're held to the same standard that somebody in one of the major American corporations is held to, as if they had the same resources. This is the type of problem that we have, and there are a lot of explanations for it. Most of them are political, some are policy. The policy-oriented ones deal with the fact that for the last century we have used the criminal law not principally as a way of demarking immoral conduct that should not be undertaken under any circumstances because of the type of harm it can cause people, but conduct that is part of a regulatory scheme, and that the criminal law is used as a means of enforcing that regulatory scheme. Why? A bunch of reasons. One simple one is that federal agents with grade jackets get a lot more respect than civil investigators who show up with their hat in hand and have to negotiate with the company's lawyers about what they can inspect. Trust me, I've been there. There is a nimbus that goes with being a federal agent that is not true in the case of a lot of others. So you want to take advantage of that. Plus, if you're a politician, you've got now a regulatory agency which has an ongoing relationship with businesses. They do this all the time. Every time they see a violation, there's a potential crime involved. And so if you add to the corpus of criminal law that the agency can enforce, you get credit, or at least can claim it, every time any of these investigations occurs. Because you can say you were responsible for passing the law that allowed all this to happen. You also, as a legislator, don't have to create an entirely new enforcement agency or investigative agency. You already got the FBI, just let them do it. They're like Mikey, they'll do everything, okay? So there are a lot of political reasons for why all this happens too. And not all these political reasons, not surprisingly, are good ones. Yes, there are plenty of circumstances where corporations or individuals will willfully violate the law in order to save money and put other people at risk. There's no doubt about that. But there are plenty of instances where people may cross a regulatory line where they are completely unaware that that line exists. So, how do you go about dealing with that? Well, there are a bunch of ways. Not all of them are legal. For example, you could have greater adult supervision at the investigative and enforcement agencies and not pursue these sorts of cases. You could have greater oversight by the legislative committees of what regulatory agencies are doing. And if they are in fact abusing their authority in this regard, the legislative committees could recommend legislation that would cut back on it. But that may not help the individual company involved. Mark mentioned that one way of dealing with this is revising the scienter or mens rea elements in a lot of criminal statutes, and that may help. You can do that in any one of three ways. You could revise the entirety of the federal criminal code, for example, as Mark mentioned, by having a commission do it or having the whole Congress do it, or your own states. At least at the federal level, that's not likely to happen. People have been trying to do that since the Model Penal Code was published in 1962, and it hasn't happened yet, and I doubt it's going to happen in my or your lifetime. You could go through each individual statute and revise the scienter elements in them. But that would be slogging through Title 18. Oh, and by the way, it's not just Title 18. It's Title 18 for the criminal code, which they call criminal code, but it's not really, because even though it's a criminal code, there are plenty of crimes elsewhere. Title 8 is immigration, Title 21 is food and drug, Title 33 and 42 are environment, Title 15 is the antitrust and securities laws. I can go on, you know this as well as I do, so it's not really a criminal code. But you could slog through that, but that would be like the same episode that the British had to go through when they were slogging through the swamps outside New Orleans in order to fight Andrew Jackson. And we know how well that went for them. The third is a default mens rea element. And that's another and possibly good way of doing it. But the problem there is, if the only thing you're adding is a knowledge element, well then you're adding a knowledge that somebody is doing X that doesn't require proof that the X was unlawful. And that's where the rubber really meets the road here. Everybody knows what they're doing unless they're sleepwalking. The problem is they may not know that what they're doing is illegal. So how do you get at that? Ed Neese and I have published an article recently trying to deal with that problem. It's actually not yet out. It'll be out sometime between Thanksgiving and Christmas. It will come out in the Northwestern Journal of Criminal Law and Criminology. It's entitled Reconsidering the Mistake of Law Defense. Basically, the bottom line that we have come to is that the criminal justice system and the criminal code are so sufficiently different from what they were at common law that it's time to reconsider the old aphorism that everyone is presumed to know the law. Put differently, ignorance of the law is not an excuse. As I said, that was a sensible proposition 800 years ago when you could count on the fingers of your hands and the toes of your feet all the crimes. And everybody knew what they were because they were part of the contemporary moral code. As Mark said, there are now, say, 4,500 federal statutes. There are, I don't know how many state ones, but Isaac and Mark can fill you in on that. And there are lots of states that have a very big appetite for criminal laws, too. The Regulatory process has found the need to have hundreds of thousands of regulations, which are probably very necessary for civil and administrative enforcement or for just regulating conduct. But for purposes of enforcing the criminal law, it just asks too much of somebody to know what's going on. So, we think a nice single-shot remedy for this would be to allow a defendant to raise a mistake of law defense. Properly limited, the defense isn't going to prove to be a big loophole for people just to sort of sneak through for conduct that they know is unlawful, that they know is immoral, they know is dangerous, they know they shouldn't engage in. Why? You can limit it, for example. You can put the defense actually into 4 sentences, so let me give them to you now. First, a person should not be held liable for a criminal violation if he or she reasonably and honestly believed that the conduct was not illegal at the time he or she committed it. Reasonably and honestly believed. If the defendant knew that what he or she was doing was illegal, they don't get off. If the defendant unreasonably believed it was illegal, the issue doesn't even have to go to the jury. After all, the judge doesn't automatically submit every defense to a jury. We know that from a Supreme Court case decided in the 70s by the name of United States versus Bailey, dealing with the necessity defense. If you don't make out all the elements of the defense, or at least present a jury question on them, you don't get it submitted to the jury. And reasonableness is a good way of getting rid of a lot of phony claims. Second, in deciding whether or not someone acted reasonably, you do not have to have legal training. Otherwise, what you're doing is measuring what the reasonable lawyer would know, not what the reasonable person would know. And it's the reasonable person that the criminal law uses. Keep in mind there is a doctrine, for those of you who are lawyers, you're probably familiar with it, called the void for vagueness doctrine. The doctrine states that a law that is unduly vague, so vague that a person of, quote, common intelligence, unquote, would not know what the law means, can't be held criminally liable for violating it. Essentially, it's like an ink blot, or written in a foreign language, or like the laws of Caligula were placed inaccessibly so that no one could see what they were. If you have an unduly vague law, you can't be held liable for it. Well, the problem here we're talking about is very similar to the problem the void for vagueness doctrine deals with, just at a different level. The void for vagueness doctrine deals with statutes at the retail level. You look at each statute, and does this statute give you sufficient information to know how to comply with the law? If yes, you can be held guilty for violating it. If not, then sorry, the legislature has to try again. The problem here occurs at the wholesale level. The problem is not that an individual statute is unknowable. The problem is the criminal code has gotten so large and is so unyielding that no one can know everything that it contains. So you have a very good doctrine, the void for vagueness doctrine, that serves as a doctrinal basis for this. And since that doctrine does not require legal training, there's no reason to require legal training for a mistake of law defense. Third, you can give courts the authority to develop it on a case-by-case basis. Mark mentioned Paul Robinson, professor of criminal law at the University of Pennsylvania Law School. He has a 2 to 4 volume treatise entitled Criminal Law Defenses that goes through in detail and discusses all this. The courts, since the common law, have been creating and working out the details of these defenses, and they do it without any statute requiring them to do it. More than 100 years ago, the Supreme Court permitted the defense of self-defense to be raised in federal criminal prosecutions. There was no statute that said a defendant could raise a self-defense claim. But it was unimaginable to the court that someone could be charged with a violent crime and not be able to defend himself or herself on that ground. The courts can be trusted with this area. They can be trusted to do it. Fourth, give the defendant the burden of production. This way the prosecution doesn't have to start out every case by bringing in all the professors that somebody had in undergraduate school or whatever and showing how smart this person was, and therefore this person should have known that this was a crime. You put the burden of production on the defendant on both issues, the honestly believed and the reasonably believed, and therefore you've cut down a lot of phony claims. Because now it only becomes an issue in cases where the defendant has raised it. And the defendant has to raise a sufficient case so that it can go to the jury. This is a way of dealing with this sort of problem by going to the legislature and having them do it, or by raising it in the courts. Keep that in mind too. You can raise it in defense in criminal prosecutions in cases. You don't have to get the legislature to approve it. Now, in the federal system, I know that can be done as a consequence of the federal court's common law rulemaking authority, and I'm sure the state courts in your own states have something similar. But it gives you two avenues to pursue. You can go to the legislature and try to get this done, or you can raise it as a defense in the courts. Either way, it gives you an opportunity to try to fend off criminal liability for conduct that no reasonable person would have known as a crime. And that, at the end of the day, is the essence of what the overcriminalization projects and movement and discussions are concerned about. With that, I think we'll now turn it over to Eric. And
Thanks very much. Let me get started with a question of my own. I was a indigent criminal defense attorney for a number of years. And one of the things that I noticed, and what I hear from friends of mine who are local district attorneys, is on the criminal side of things, as opposed to regulation as crime, it breeds to some degree a laziness at a local level when people just say, oh, we'll let the feds handle this. And at the same time, it breeds mass confusion, it seems like, among local district attorneys over where jurisdictional boundaries should be for crimes and who's going to prosecute what, and why should this be a federal crime versus a state crime. What's the guidance, I guess, that any of you could offer for not just on criminalization as business regulation, but also for local district attorneys and local and legislatures? Where do you draw some good guidelines on where they should, I guess, beef up or scale back their interaction with the federal government on crimes?
Well, I mean, unfortunately, I think the federal government's been driving that train. But on the other hand, you're absolutely right. A number of prosecutors sometimes local prosecutors will invite the federal government, or the AG will, because they want the tougher penalties or the greater investigative resources that the federal government has. So it's a bit of a dilemma. But clearly, I think the 10th Amendment ought to be the right line. Very little makes federal crime now really, in the true vision of what the Constitution means, really should be there. I do want to just pick up on a couple of things that they said. First, with regard to what you were saying, one thing I want to emphasize is, with some state of the law defense, is that it doesn't require that someone know chapter and verse what the law is, just something generally is illegal. And I think that's really, is criminal. And that really is happens appropriately. The other thing with regard to what Isaac said, I thought about this a while back because like some of the law enforcement things that were done in New York City too, the important thing to remember with all the broken windows things, and I'm sure you'll agree with me, is they didn't put those people in jail. Many times they gave them warnings. And I would actually argue one thing we need is more police diversion. And that is, it can happen in a number of ways. One of the areas within restorative justice is, a 6-year-old steals something out of my garage rather than this thing even going to the prosecutor's office. The policeman works with me and that 6-year-old, his family. We get a fine restitution agreement. He does some community service, pays me back, obviously. And, we have a system now, though, of course, where, A steals something from B, and so therefore C does something to A. And the government has essentially occupied a lot of the role that victims used to occupy. In colonial America, for example, victims brought their own prosecutions in many instances. Obviously, it's not entirely realistic to go back to that. We've had a much bigger society and we're disconnected and so forth. But I really think we need to go back to the notion that that the victim getting restitution and what the victim wants ought to be central. And we now have a system where the problem is the government is central.
There's a conceit that federal law enforcement agencies are better qualified, better trained, and have deeper pockets, bigger, greater resources. And the answers to that are probably no, maybe, and yes. There's no question the federal government has greater resources than any particular state or locality. We're talking about just that. Assets the federal government has that the state and local people don't have. And if you're talking about a case of you're going to need that sort of resources. If it has an interstate or international component, then yeah, the federal government is what you want to go to. If we're talking about wire transactions, it's a lot easier for the federal government to put all that together. But the bulk of what state and local people handle are what would be deemed street crimes. You don't need the federal government for that. Actually, I came from a family on the NYPD that they could handle those things without a problem. They don't really need the federal government for that. And bringing the federal government in for that is like getting stuck with flypaper. Once the federal government gets its mitts on one of those matters, you never get rid of it.
Let's open this up to questions from you guys.
Thank you. I'm reminded when I hear this of a controversy in 1970 that I participated in over the Brown Commission proposed criminal code. If you think what we've got now is horrible, you should go back and read that. It was ultimately defeated by a coalition of the business community and the civil liberties union. But what we've had since is an explosion of federal criminal jurisdiction. In those days, you had an FBI with about 18,000 people, and you had 1 million state and local police. Now you have more than 100,000 federal law enforcement people. Mr. Justice Jackson, who was frequently invoked as an expansionist as far as federal jurisdiction is concerned because of Wickard versus Filburn, was horrified by any expansion of federal criminal jurisdiction. He said American experiment in liberty will be over if you have 1 million federal police. And so it seems to me that if you're arguing this case, and it's a case I agree with, you need to make not only the points you can make, which sound like you're making a case for the business community, but you need to make the broader argument, namely that this is a danger to liberty for institutional reasons. We don't want a huge federal criminal establishment. We now have one. And that brings me to the drug question, which is the elephant in the living room, which is being revitalized by the 2 referenda that we're familiar with. And I think the point to be made there is there are agencies of social control other than the criminal law that haven't been explored. It's very strange that if you want a job at McDonald's or the local supermarket, you have to take a drug test. But if you want a Harvard diploma or a diploma from your local high school, they don't test you at all. They have a total blind eye to drug use. And obviously, the testing and treatment regime would be far more effective in deterring drug use than the failed efforts, and they are failed efforts in the last 40 years. All the statistics show the numbers are exactly the same as they were before the war on drugs began. As far as 20% or 25% of the young people use marijuana, the other drugs are at about 2% levels. None of that has changed. And it might well change if you had a really thorough testing and treatment regime, which schools and colleges won't do now, but for the very simple reason they don't want to incriminate their students. I wonder if you would react to that.
Well, we need to have another panel. I think one of the issues that we haven't touched on is come up with a drug war civil asset forfeiture. The Institute of Justice has done some tremendous work on it. But this, by the way, happens in your states. It happens at the federal level. That people's assets are seized when they're pulled over. And they often have to go to great lengths, even if they're ever charged with a crime, let alone convicted, to get those assets back. And one of the things we've actually got in Texas also is prosecutors who got half of those assets, law enforcement got the other half, but the prosecutors, many of them, not many of them, but some of them were going to Hawaii with those assets, some of them are holding margarita parties. So we did pass a bill to rein that use of the assets or misuse, but we need to also look at saying, and ALEC has done model legislation on this that's passed, the Institute for Justice presented it, that says, your property shouldn't be taken away from you, until you're convicted of an offense, unless, there are very limited circumstances. So obviously, if you're dealing with international terrorism or something like that, there's differences. But I think we need to look at that issue, and obviously there's a host of other issues with the drug war that we probably don't have time to deal with.
Let me say something about the first half of your remark. I think one of the problems in federal law enforcement today is the proliferation of different law enforcement agencies. There are a large number of regulatory agencies with their own law enforcement personnel. One of the problems you have in that regard then is a lack of loss of perspective. The same sort of problem that people criticize the independent counsel statute as creating, a loss of perspective. You are assigned to investigate one person, you're likely to find something that he or she did. If basically you spend your day working with a hammer, then everything looks like a nail. That's a big problem. That is a separate problem and needs to be addressed separately because it creates a lot of difficulties because you wind up with misallocation of resources and the problem we're talking about here. But it is part of what you were concerned about in the very first comment you made. Yes, there's a need for the federal government to handle interstate, international crime, not local. But that doesn't mean you need every federal regulatory agency doing it on its own.
Yes, one comment, one quick comment, one question.
We're short on time.
In Atlas Shrugged, there's a line that talks about how if you want to control business, I'm paraphrasing, you need to make these laws that are unreasonable in order for them to break them, to break the laws. And so that was the comment, that these are intentional and that it's pushed by a culture of envy, the left, who don't necessarily create businesses, but they can take them down and they can gain power over them. So I feel like we're up against a much bigger moral obstacle than just, misunderstanding things. The second is I'm so curious why you went all from a federal agent to what you're doing now.
Gee, I've done a whole bunch of things in my life. I guess I have the adult version of ADHD or something, so that I can move around a lot. I was at the Justice Department for close to a decade. I started out as a law clerk. I did 2 tours of law firms. I was at the Justice Department, 2 different offices. I missed being a lawyer. That was part of it. And, other matters factored into it as well. No, it wasn't. Cool.
I don't think also that we kind of respond to the first quote we use. I think that the biggest problem is not the implementation of business conduct. There's some business conduct where the case can be criminalized. It's the manner in which it's done. And most of the time, especially now, we see cases where there's already on the books, there are laws that already make that conduct that's being committed criminal. It's there. You don't have to create a new criminal law, a new regulation to address that issue. And yet, it's still every legislator, like Paul was saying, is clamoring to get their name on a bill to get credit for addressing this issue. That's one major problem. I'm reading all these laws. There are laws in the books before those were even promulgated that already address those issues fine and well. Now what they're creating is this huge expansion of things that overlap, contradict each other, that you can't make sense of anything.
There was one last question. Right back there.
Yeah, I was just wondering if you had any opinions on jury nullification, just the practice in general, whether you look at it favorably. I know you mentioned the panels mentioned a couple of defenses that would argue about the conflict of the law rather than the conviction of the act. Obviously, they would mistake the nullification.
Well, that's a great question, and I think one of the questions is, should juries be able to decide just the facts or also the law? And essentially nullification is when the jury says, even though the facts that they were presented with establish that someone violated that law, they don't believe that law should be criminal. And so, that's something we really haven't dealt with. I think one of the interesting things that people should realize is just by being indicted, you have a tremendous loss of reputation. So even if the jury saves you by being nullified. And one of the perfect examples is Arthur Anderson. Of course, the federal government only dropped the case, no one was ever convicted. They took down a whole firm just by indicting him. Any company, as soon as they're indicted, they can no longer get federal contracts called environment. So So if you're in the healthcare business, everything's Medicaid, reimbursement, Medicare, you're gone just by being indicted, but it's still an important issue.
I mean, yeah, I was thinking along the same lines, you know, there's so much that goes on before that even comes into play, just, you know, like what Spitzer was doing, just getting the public aware of this, just the threat of it, just the investigation itself already has the potential to just cause disastrous results. So I would initially put my focus on that process and trying to limit the harm that causes from that. Arthur Anderson is a great example of that. The Supreme Court indicated that it was too late, the company was gone. That was it.
Yeah,
Go ahead.
I was going to say there are empirical and moral aspects to this. I don't know to what extent when jury nullification does occur, it is because the jury disapproves of this particular prosecution, or they're using this particular prosecution as an opportunity to voice their displeasure at something else the government's done. I don't know that, and I don't know if anybody's ever done any type of analysis to try to figure that out. It may be that this is just their only opportunity to send a message to the government, so to speak, and so they use this for them. On the moral side of it, I mean, this has been an issue that was debated principally back late in the 60s and early in the 70s when the government was submitting draft dodger cases to juries. And the question was, should people be told that they could refuse to convict somebody if they believe that this was an unjust, immoral war? And that's the sort of matter that has been debated ever since. There was a professor at GW, for example, wrote an article saying that black communities that are seeing too many black defendants go off to prison for too long periods of time because of the mandatory minimums, that juries should feel free to nullify the law in that regard. I mean, the problem, of course, is to the extent that those laws are designed to protect the people in the community against the harms of drug dealing. By letting a drug dealer go, you are inflicting perhaps even greater harm on the community. So it's a difficult moral problem as well, and I don't have any particular view on where to go.
This has been a panel by the Texas Public Policy Foundation, Right on Crime, on overcoming overcriminalization. We are withstanding between you and a cocktail party, so